So my name is Michelle Beda. I'm a legal advocate and I work for TRAC, which is based out of Vancouver. It's the Tenants Resource and Advisory Center. I always got the name wrong. We operate provincially, though, in the sense that we run a tenant info line where people call from all over the province. And I, as a legal advocate, do direct representation for people throughout the province, although because I'm in Vancouver, my work is concentrated in the Lower Mainland. I'll just go ahead and start with the slides. The basis of a 12-month compensation claim is found in, obviously, the Residential Tenancy Act. Some of the regulation is in the regulation. So in order to qualify for a 12-month rent claim, a tenant has to have been served either with a Section 49 landlord use notice to end tenancy. So that's a 2-month notice if a landlord is moving in themselves, or if a close family member is moving in, or if there's a family corporation. The other possibility is a 4-month notice for landlord use, or for renovation or what have you. Or now, if the tenant has been under a fixed term lease, a Section 41 fixed term lease, which has a vacate clause. And as of 2017, the only time you can have a fixed term lease with a vacate clause, so one that specifies that at the end of the tenancy ends and the tenant must move out, is if the landlord has said that they intend to move back into the property. So I'll just go through those sections. Section 49.3 is the one for a landlord who's an individual. The same is true if the landlord is a family corporation as defined by an act. Section 49 sub 5 is if a landlord is selling the property and the purchaser or a close family member intends to take over the unit. 49.6 is the 4-month notice for, or sorry, the 2-month notice for demolition or conversion to another use. All of those types of landlord use evictions will qualify if either if the landlord is successful at a hearing or if the tenant just accepts the notice and moves out. That's kind of the foundational criteria you need to make a 12-month claim. In a lot of cases, unfortunately, what we're hearing is people who did not move out under one of these notices. Instead, they were just told to move out or asked to move out. You know, there was an informal kind of back and forth between the landlord and the tenant about, you know, the landlord saying, oh, I need to move in, or my son or daughter needs to move in, and when can we make this happen? And coming to terms about the tenancy ending that way, but without ever actually receiving this formal form of notice. So in some cases, too, what I've seen happen is a tenant will receive a 2-month notice, and then they can't find a place in time. They have some discussions with the landlord about maybe extending the time limit for them to move. And then they end up signing a mutual agreement to end the tenancy on that date instead. This is a risky move on the part of the tenant, because when you sign a mutual agreement, you will not qualify in all likelihood. There's a caveat to that I'll come back to later, but if you sign a mutual agreement to end the tenancy because you've come to terms about something else, but that's the document that's in front of the parties, you probably will not qualify for a 12-month claim. And the mutual agreement form itself, I've just cut and pasted it from the website here. This highlighting is actually on the form itself, at least if you print it out in color. It's really explicit that the second or third sentence there is, if you are the tenant, this may include foregoing any compensation you may be due if you were served a notice to end tenancy. In a lot of cases, people will come to us after they've signed one of these agreements and they've said, well, now my landlord is saying they don't have to give me my month's free rent. The plain fact of the matter is they probably don't. There's a very strong presumption in law that parties don't sign agreements unless they've read and understood and agreed to all of the terms. And this is made, it's made so explicit in this tenancy, in this mutual agreement and the tenancy form, that it would be really difficult to undermine that afterwards. Question. There may be in this scenario where a tenant's actually already been served one of these notices and then they come to some other mutual agreement about the end of the term, that may be fine. And if a tenant, if a tenant comes to you for advice in that situation, you would want to make sure that the agreement that you came to still specified that you were moving under the notice. That can also form part of like settlement discussions. If your tenant has disputed a 2-month notice, if the tenant then finds someplace and decides they want to move, or the landlord is willing to entertain some kind of other arrangement, you just want to be clear and explicit that the tenant is still moving under the notice. Or if you come to a settlement agreement in the hearing, sometime the arbitrator is alive to that issue and they'll clarify, but if not, then you or the tenant should specify, if a settlement is agreed to at hearing, the tenant is still moving under the notice. That hopefully will preserve the tenant's right to make a compensation claim if in a few months it turns out the landlord didn't move in. So the other situation where a tenant can now make a 12-month rent claim is if they have entered into one of these fixed term leases with a vacate clause. This was a huge loophole that I'm surprised it took this long to close, because there was absolutely no consequence for a landlord who said that they were resuming occupation or taking up occupation of this unit once the tenant moved and then never did. Or they could, without shame or trying to hide it, move in for 1 day or 2 days. There was nothing in the act that specified, or in the regulation that specified, how long they would have to move in. Question? They can't amend it unilaterally, so they couldn't impose that condition on the tenant. The tenant could agree to it if I don't know why they would, but yeah, no, in that situation, otherwise, if the landlord did decide they wanted to move in, they'd have to serve a notice. And the question at the front?
That 12-month rule, hasn't it been like about 1.5 years? And prior to that, I think it was 1 or 3 months.
Which 12-month rule?
Like if a landlord claims he's going to use it for personal use and he doesn't, and then the tenant files and it's determined that the landlord never used the property for personal use, that rule there, hasn't that been around for about 1.5 years? And prior to 12 months, it was 1 month of compensation?
Before it was 12 months, you could get 2 months.
Oh, 2
worth of
months. 2
compensation.
months. I
Yeah.
thought it was 1 or 3.
The 12-month claim has been around for a while. I don't remember how long.
Yeah.
What's new is the fact that tenants who were in fixed term leases with vacate clause can now make this same 12-month rent claim. That's legislation that just came in I think in July.
Okay. Oh, they weren't able to do that before.
No, before, if you were a tenant and you were in a fixed term lease with a vacate clause, you'd have to move out at the end of the term. If the landlord didn't move in, there was nothing you could do. You had no recourse.
But weren't all vacate clauses just deemed to turn month to month at the end of them?
Yeah, there's now only one way in which a landlord can have a vacate clause, and that's if they set out at the outset of the tenancy that they are going to be taking over the tenancy at the end. So if you look at a
Yeah.
RTA tenancy agreement, there's still those little boxes in box C or whatever that says, if this is a fixed term, you have to initial here if the tenant has to vacate on the last day, and it has to be compliant with regulation, whatever the regulation is.
Lastly, the landlord, they'd have to use the property under good faith or for at least 6 months.
Yeah, anytime a landlord gives a 2-month or a 4-month notice saying that they're going to be using it, they do have that good faith obligation. And if they don't do it, a tenant is eligible for this 12-month claim. This is just a new provision that allows tenants who are under these fixed term leases with vacate clauses to get that compensation. So here's the section itself is section 51, which explains tenants compensation to section 49 notice. So again, section 49 are the provisions that allow for landlord use. So here's where it sets out that if the landlord doesn't accomplish the stated purpose for ending the tenancy within a reasonable period, then if they've served a section 49 notice, the landlord must pay the tenant 12 months rent. This is where there is a little bit of ambiguity with the this is where there's a little bit of ambiguity where if a landlord has served a 2-month notice, even if there is a subsequent agreement of some kind, there's a little bit of wiggle room to potentially argue that the tenant should be eligible for compensation, because the section only specifies that the tenant has to have been served the 2-month notice by the landlord. It doesn't explicitly say that the tenancy has to have ended under that notice, or that there can't have been some amendment of that notice. It's a little bit, I don't know how successful you could be making that argument, but if you do have a tenant in that situation who says, well, I was served the notice, but then my landlord and I talked about it and we agreed, to these other things, and now he's saying he doesn't have to give me the compensation. You could try to argue that if it comes to making a 12-month claim. It's pretty low risk, a 12-month claim. You just have to pay the filing fee. But anyway, this is the forward. So, I'm going back, sorry. This is the new section. So 51.1 sub 2 now says that if a fixed term tenancy with a vacate clause, if the landlord doesn't move in, then that tenant is also eligible to make a 12-month compensation claim. They've written into legislation. It's now in legislation that it's a 6-month period, which means that could be changed. It would be fairly straightforward to change that period of time that a landlord has to move in by order in council. It wouldn't require a legislative change. But for right now, it is 6 months. And when you're looking for, basically, when you're looking for details on this, if you want to advise a client, you can just go to the policy guideline. They've updated guideline 30 on these fixed term leases with the vacate clauses. And they've said in the policy guidelines specifically that occupation. So if a landlord has a place, they rented it out on a fixed term, tenant has to move at the end. The landlord does have to move in, but they've specified that their occupancy can be part-time. So a question at the back, and I think they want a microphone so that Zoom people can hear it. Yeah, sorry, it was you.
Just for a little bit of clarity, that this where the landlord can stay on weekends, like, could they just like show up the first weekend of that 6 months and then the last weekend of that 6 months and call it a day? Is that still considered?
I'm going to say, yeah, they probably could
Yeah,
because
I
of
thought
some
so.
information that's forthcoming in one of these slides, which explains that the burden of the onus of proof has been reversed
Mhm.
for vacate clauses. So a big victory, in my view, for tenants was that the legislation was changed so that the burden of proof in these claims was shifted over to the landlord. So originally, when the 12-month compensation claim was first implemented, the tenant had to somehow prove that the landlord had not fulfilled their intention. Sometimes that's easy if the landlord was totally oblivious and just immediately re-rented the unit on Craigslist, and you could call and get a viewing and take a video and prove that the place was being rented. But in other situations where the landlord bothered sort of covering their tracks by, I don't know, putting bills in their name, for instance, then they could submit that into evidence for a hearing and say, no, look, see, I moved in, unless the tenant had hired a private investigator to go and surveil the home for an extended period. Really difficult to prove that somebody hasn't done something. So it was really, it gave this provision some teeth when that onus was shifted. And once the claim was made, the burden of proof was on the landlord to prove that they actually had moved in. For some reason, when the new provision for vacate notice was implemented, that burden of proof was kept on the tenant. Not accidentally. I'm just going to go to the guidelines up here. So for the section 49 notices, burden of proof is the onus is on the landlord to prove that they accomplished the purpose. That's for these section 49 notices. For the vacate clause notice, inexplicably, the onus is on the tenant to prove on a balance of probabilities. That's really tough, especially in a scenario where they've already said that the landlord could live there part-time and weekends only. I feel like quite probably that scenario you described where, yeah, they show up when you're moving out with some bags and they camp out there for the weekend. I feel like it would be pretty easy for them to get away with just re-renting the unit on some basis after that.
It is.
Yeah. Yeah. Yeah, it's not much use, especially in places where, there's a lot of vacation housing and anywhere, Whistler, Kamloops, that kind of stuff. But going back to the policy guidelines, so policy guideline 50 is where it sort of sets out all the information that you need to know about what the basis of the claim is and what the landlord is expected to have to prove. There's definitions there, or at least expansions on the meaning of the terms. What's a reasonable period? What does it mean to have accomplished the purpose? And what does it mean to be using the unit? There's also some information on, you can look at the policy guideline for what constitutes occupying the unit, whether it can be held for vacant possession. Early on, when they implemented these claims, landlords were being successful taking over a unit and then just leaving them vacant for a long period of time. And finally, there was a decision, a Supreme Court decision that said, no, you know what, occupy has a common sense meaning, and that meaning is that somebody's living there. You can't call it, you can't keep it vacant explicitly and say that that's your form of occupying the unit. Having said that, it's good to know that reclaiming a rental unit as living space is allowable. So if your tenants are in a basement suite, they're in a 2-bedroom, and the landlord says, well, we need that space for our own use, it doesn't necessarily mean that they have to move in somebody into that unit as a unit. They could just, take out the connecting door and be using that space as a family room or a painting studio or whatever. What's that? A gym, exactly. I think when I was at First United, somebody there had a case where the landlord claimed he needed a whole unit for his painting studio. And that was successful. And now that's basically been encoded into the policy guideline that yes, that's okay. If you live upstairs, you can reclaim this unit. So there's some details there about that, about the definition of occupy. Generally speaking, you have to live in it. For policy guideline 2B is about the other type of landlord use, eviction, where a landlord is ending a tenancy to demolish or renovate. And this is another avenue for 12-month compensation, because under this legislative framework, a landlord has to offer a right of first refusal where a building is being redeveloped. That's often a meaningless obligation because, of course, if you're bulldozing an old 3-story walk-up and building a luxury condo, your apartments are going from $800 a month to $3,500 a month. Offering a right of first refusal is useless to most tenants who couldn't afford that in a million years. But if the landlord fails to offer that right of first refusal, then that does potentially entitle the tenant to make a 12-month claim. Yes. Microphone.
So then, my understanding of the right of first refusal is that it applies for the landlord when they have a building 5 or more units. The tenant puts in the right of first refusal, but the landlord must give a 45-day notice of availability. And if the landlord fails to give that 45-day notice, that's when the tenant can make that claim. Is that correct?
Yes, that sounds right to me. I just clipped out the part of it from the policy guideline here. Yeah, it's the point at which it's been clear that 45 days, whatever is up, that you know that you've missed out on this opportunity, you can file for that claim. It's also good to know that there is a 2-year limitation period for this type of claim after the tenancy has ended. So often we get calls from tenants who are like, my landlord evicted us for landlord use and it's been like 6 weeks and we live nearby and we know that they haven't moved in, and when should I file my claim? You should probably wait some period of time, because once the landlord gets notice of your claim, they can make arrangements to move in or fake moving in. And it would make it more difficult to be successful at that claim. It makes more sense to wait out the time period, because if you file too early, you're giving the landlord the opportunity to tailor evidence, basically, or to say, oh yeah, well, we didn't move in the first 6 weeks because whatever, there was mold, we had to replace the carpet, we couldn't find workers to come in. So although people are anxious to get that claim in and hopefully get their 12 months, it's important to be strategic about when you actually file. Having said that, you don't necessarily want to wait 2 years. Once you have the evidence and you feel like you have a good case, you should file it. The longer you wait, the harder it is to get a hold of witnesses and evidence and the rest of it. Okay.
Sorry. So then there's the 4-month notice for renos, repairs, demolitions, and conversion. And so normally when a landlord provides these 4-month notice, there had been a change in which the residential tenancy branch needed to approve a landlord to provide the 4-month notice to the tenant. So now my understanding is that landlords must put in permits only for repairs and renos, but not for demolitions and conversion?
That's right. They've split the 4-month notice. I should have put that in because I find it confusing. It's hard to remember. But yeah, if you have a regular, like a renoviction notice, like your landlord is saying, I'm going to evict you because I'm renovating your unit and I need vacant possession. That's a new process where the landlord has to go before the RTB. They have to prove to the RTB that they have all their permits and permissions, that they're in place, that they need vacant possession, all of that stuff. They have to prove it at the first instance. And only then, if they're successful at that hearing, will they be able to give the tenants 4 months. And the tenants, they have that chance to dispute it at the first instance. But once the landlord's approved, the landlord basically gets orders of possession. Like they then give the tenants 4 months to move. These 4-month notices for demolition, redevelopment, or change of use are still under the old process. I should look that up. Sorry, I don't have my computer. The old process where they would just serve a notice. And if the tenant wanted to dispute it, they would have to file to dispute it. Did that answer your question?
It's still confusing. Sorry, I know you're saying it very clearly, but it's still confusing in the sense that why would you go through the problem of giving a 4-month notice, right? And then for demolitions and conversion, you need to have permits, but you don't get to go to the RTB to get approved to give the 4-month notice, right? So you just have your permits, and then you just give them the 4-month notice without going to the RTB.
Yeah, I don't know why they did it that way. I don't know why they didn't just have all the 4-month notices go before the RTB. Maybe they thought in cases of demolition or conversion of use that it would be that was less prone to abuse. We're all laughing knowingly, but I'm speculating that was their rationale. They certainly have seen, it sounds like, from the numbers, that renoviction notices have plummeted. Like landlords simply aren't serving these kinds of notices, knowing that they have to prove that they're legitimate ahead of time. Question at the back.
I've seen one in about 2 years, and it was so far from proper that when they went to the hearing, the arbitrator looked at the notice and said, well, you know,
Laughed at them.
yeah, just like, so you've got asbestos, you've got this, you've got that, and no permits, and you've ticked off that you don't need any. Yeah, no.
Yeah,
But that was the only one I've seen in a long time, which is good.
I don't remember the numbers offhand, but the RTB keeps track of these, and there were only, in the sort of double digits of applications, 30 or something, and then like half of them, again, I'm just kind of spitballing these numbers, but were either not successful or they were just withdrawn. Like, yeah, if they did that for all notices, save a lot of trouble. We've already talked about the burden of proof, the shifting burden of proof. And that's basically it. That's all my slides. So your genesis for the 12-month claim is having been served one of these notices on the one hand, or on the other hand, having been in a fixed term tenancy with a vacate clause. And then if you'd been served one of the landlord use notices, your possibilities are if the landlord basically didn't use the premises as promised, or if they redeveloped, if they didn't offer you a right of first refusal. So certainly most of the cases that I see and hear about are these straightforward 2-month use for landlord or 2-month notice for landlord use cases. The RTB has said that they haven't seen an uptick in those kinds of notices since the 4-month renoviction thing. I find that really, really hard to believe just because of the number of calls that we get about it and the number of really seemingly spurious landlord use notices that we're seeing. But it could well be that they're just not, like most people don't dispute an eviction.
So this was approved on July of this year, right? So the tenants cannot bring a claim from previous years.
Hold on, and we'll ask it on the microphone for the Zoom.
Thank you.
For the
So,
Zoom viewers.
The vacate clauses are under letter E of the rental agreement. And then the landlord must definitely fill out that space that says you must vacate for these reasons,
Yeah.
13.1, blah, 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 blah. But what I would like to know is the vacate clauses have been approved since July of this year. Now, can you bring forth a claim from previous years?
No,
Perfect.
but if you're in one of those existing tenancies now, then you can apply if things go wrong at the end. And the arbitrator has discretion to consider whether you should be allowed to. So they didn't make the provision retroactive, but they did allow for the possibility that it would have an effect on a current tenancy. I think that's reasonable. And I think that probably arbitrators would do that. I mean, when that vacate clause is quite specific that you have to intend to move in, it's not really reasonable for you as the landlord to then show up at a hearing and say, well, yeah, that's what I put on there, but I didn't really intend to do that. And there was no consequence at the time. So you should honor that, the fact that there was no consequence, and not impose one on me because now there is one. Anyway, what was I saying? 4-month notice, 2-month notice. Yeah, we're seeing a lot of 2-month notices that are being issued in bad faith, that are being disputed on the basis of bad faith. We're also seeing a lot of, I don't know, we're seeing some really terrible decisions on bad faith. We had a case at TRAC where the landlord said his daughter was moving in, but then even at the hearing refused to say who his daughter was. He wouldn't provide a name or any details or information or a statement or anything saying that she was moving in, and that eviction notice was upheld. So it's useful that they have this 12-month provision, that they've shifted the onus to the landlord. But there are still complexities with making these cases, especially if where the property's been sold, because then you have a situation where it may not be straightforward to find the previous landlord, and you do always want to name both. Someone was talking about a case they had where they tenant had brought a 12-month claim against the purchaser because the purchaser didn't move in, but it turned out the purchaser had never asked the seller landlord. They'd never given a written notice. I guess the seller just figured it would be easier to sell with a vacant property. So they just served a notice claiming that the purchaser needed vacant possession. But once your landlord has sold your house and moved, it's not always easy to find them. You do always want to do a title search of the house, especially if you're waiting, a year, 6 months or a year before you're filing. You do a title search of the property and find the current owner, which may be different from the purchaser who was on the record at the time the notice was given. But it can be difficult to find the selling owner. I think there's another question back there.
Sorry, I feel like I'm asking a lot of questions.
No, that's good.
Can you speak at all to enforcing a monetary order? The reason I ask, I've been successful in quite a few of these 2-month notices. Oftentimes it's just a picture of the Facebook ad and a copy of the notice. I'm in the middle of one right now where my tenant was awarded quite a bit. It took us a lot to get the landlord to comply, a couple of settlement conferences, demand letters, the whole 9 yards. So the landlord started paying her a monthly payment. And when he got to about $5,000, he stopped. So he was paying about $500 a month for the last year or so. Now, would I have to do another settlement conference to re-get all of his financial information to freeze his bank account, to put a lien on the mortgage, all that kind of stuff? Or would I just be able to do that now?
I'm not really sure. Do you have a payment order? Like
Yeah.
you have a payment order of the judge?
Yeah, payment order states that he has to pay $500 a month on the first of every month until the debt is finished.
I'm not a lawyer. We do
Me
have
neither.
the Housing Law Clinic does do some collection work of that kind. They can't do too much because it's time consuming and often very difficult.
Mm.
But I think if you have an existing order, I would just look into enforcement of that order.
Mhm.
I mean, can't the debtor be like arrested? if
No,
they're not
it's
complying with
on the
with
advocate.
the order? Sorry?
Once you get that monetary order signed by the judge, in my experience now anyway, and where in my community, the judge basically puts it on me and says, okay, well, now it's up to you to do the collections.
Right.
So freezing the bank accounts and putting the lien on and all that kind of stuff.
Yeah, I'm not sure. Unfortunately, I can't really
Yeah, me neither.
speak to it.
Thank you. I was just going to ask if your client had thought about giving the debt notice over to a collection agency, because they sometimes take a fee and then they'll do the collecting and deal with all that themselves. And in the past, not for anything residential tenancy related, but for different collections, we have used in Abbotsford. I have used someone that my client wanted to use because they didn't want to kind of do everything that was required.
To my understanding, because there's a monetary order and it's between the two people, that a debt collector, like, it just wouldn't work for her. My client doesn't, it just wouldn't, we wouldn't be able to get there.
Yeah, I mean, there's very powerful enforcement mechanisms that you can use through provincial court, including, like you said, garnishing wages, garnishing bank accounts, putting liens on properties. So I think it's just a matter of, it can be difficult and time consuming and tiresome to pursue those. But as to your specific question about whether you need to have another payment hearing, I'm just not sure. I would, you could contact the housing law clinic and see if they might be able to give you some advice about that. I'm sure they'd be glad that somebody else is taking on some monetary order enforcement, which is, of course, the compliance and enforcement unit won't do that because those mechanisms do exist. They're well established. It's just not always easy for people to access them or actually use them. The other thing I was going to talk about was the evidentiary basis for these kind of 12-month claims. So even in cases where the onus isn't on the tenant anymore, whatever evidence the tenant can obtain that this is not happening is obviously going to be helpful. Like I said, unless you can hire a private investigator and do surveillance, how much evidence you can actually gather depends on how much access you have to the place. But a lot of times people are, especially if it's like a condo unit or something, they still have friends in the building. They have neighbors who would be willing to keep an eye on the place. They might live in the neighborhood and be able to stop by. We had a case where the tenant was able to go, they were given a notice just for landlord use, the landlord was moving in, and then immediately a massive renovation project started. So they were able to go by the house periodically and take photos of like the stripped down house and the muddy yard and the equipment and the fact that it was clearly vacant. They could see into the house and nobody was living there. Sometimes people have been able to, this is less common in buildings, but if the mailbox is out at the corner, or if it's like a shared house situation where all the mail is going to one place, again, you might be able to recruit Confederates who still live in the house to take a photograph of the mail and show that, you know, the name, at least the names don't match up. Like it's not the landlord's family that is collecting mail at this unit. If you have a situation like you mentioned where there's a Facebook ad renting out the place, if you can also, if the tenant or a Confederate can then contact the landlord, get some email confirmation that yes, it's for rent, yes, it's newly renovated. We had one case where the tenant was able to get a friend who went and chatted with a real estate agent who was showing the place and explaining how the landlord wasn't going to move in, like almost explicitly said, like, yeah, they served a notice to get this tenant out, but they're not really moving in. And we're just re-renting the unit. So the more evidence you can put before the arbitrator, the easier it's going to be for them to find that the landlord hasn't met their burden. You're basically piling up a little mountain that they then have to climb over. The more they have to justify, the harder it's going to be for them to persuade an arbitrator. I think that's basically the extent of the sort of information that I have for people. Do people have questions or they want to ask about claims that they're facing or questions that are coming up for their clients? Happy to discuss people's cases. Dooney?
I had a question about a case where the landlord issued a notice because they wanted to convert the unit for a caretaker. I just don't know, like, what sort of evidence and how would the tenant, I mean, the tenant says there are other units that the landlord can use, right? Like, why does it have to be his own unit?
Is this for a 2-month, like disputing a 2-month? Disputing a 4-month?
Disputing a
or you're
4-month.
talking about the 12-month claim?
Not the
Okay.
12-month claim, yeah.
Yeah. Again, the burden of proof is on the landlord in that case. So yeah, if they can, any evidence they can raise, so any suggestions they can make like that, like there's lots of other units. Why my unit? Other units would be more suitable. And you can find, if not, I don't think there's case law on point, but there's certainly decisions of previous arbitrations that have said, like, there was a case where a guy lived in the penthouse apartment and the landlord said, oh no, I need that for my caretaker. Like, yes, there is a caretaker unit in the building that I could use, but we really want him up in this nice penthouse so he can look over the roof.
Yeah, I mean, I find it tricky because even though the burden of proof is on the landlord, I've had one case where we were unsuccessful because, you know, we didn't have, even though we had pictures and showing that the landlord wanted to rent out the unit, but the arbitrator still found that the landlord had proven that he was acting in good faith. So I mean, I don't know how it's going to go at the hearing if we don't have like stuff to point the arbitrator to saying, you know, very strong. I feel like they say the burden is on the landlord, but in a way it's still kind of on the tenant. Yeah.
Inevitably, it really is. And what you can do in those cases is just try to challenge the landlord's evidence to the arbitrator. You can suggest that, you know, they don't have, whatever evidence they bring is not conclusive. You can suggest that they've submitted stuff or said stuff that's like easy to say and not necessarily do, or easy to retract. But I get what you're saying, like, even though the burden of proof is on the other party and that it should be easy to prove that you're doing something if you genuinely intend to do it. Yeah, I've lost cases. I lost a case where there were 4 tenants in a quadruplex, and the purchasing owner, who lived in Ontario and owned property in Ontario, claimed that he and his family were taking over each of the units, even though this was a tear down, you know, an hour and a half commute from UBC, where his daughters were currently living and going to school. And those 4 units then showed up on Facebook Marketplace at $3,000 to $5,000 rent within 6. Well, they were trying to rent them out furnished as like executive long-term stay places. And I had, you know, I got the landlord to admit that he didn't live in Vancouver. Not only had he never seen the property, he hadn't even done a video tour, that his daughters, even though they lived at UBC, had not come to look at these units, that they didn't show up to give testimony. We put all of that before the arbitrator and said, you know, you should be drawing a negative inference from the absence of this kind of evidence. And we were still unsuccessful.
Same. Yeah. The one that I lost, the landlord didn't even submit anything. Like, he just said, yeah, my son is moving in, and I've offered the tenant, like, I've been so kind to the tenant, and I'm trying to make this easy for the tenant, and, you know, all sorts of things, very superficial.
Irrelevant.
Yeah.
Yeah.
And he was successful. So I'm nervous about this one coming up. And
Yeah. And what I always tell tenants is like, well, if they're honestly doing this in good faith and they're going to move in, then they're going to move in. And if they don't, then you have recourse to this 12-month claim. And at least now the burden is on the landlord, and you will have a decision that hopefully records some of these claims that the landlord has made. You know, yes, my daughter's coming from UBC. Yes, my other daughter is also coming from UBC. That's kind of the sad little silver lining to these, how difficult it is to win these bad faith hearings. I had actually, for the quadruplex case, I had a reasonable arbitrator. I don't remember who offhand, but it wasn't somebody that I was like, oh no, when they got, you know, they listened to the evidence. They were receptive to the arguments. I feel like a lot of arbitrators cannot get over the idea that it's somehow unfair to fetter a landlord's rights about their properties. That seems like a really strong bias that's very difficult to overcome. I have another case right now where the tenant's already won a 2-month bad faith claim against their landlord, who then turned around and refiled a new 12-month or 2-month notice within a few weeks of getting the original decision. And the arbitrator would not hear arguments about res judicata and just kept saying to the tenants, they had one hearing without me and then it was adjourned, kept saying to the tenants, well, that's ridiculous. It's not fair. You're saying the landlord can never serve another 2-month notice. Like, that was in the past. This is now. They have the right to live in their home. That's a very bad arbitrator. But even the arbitrators that are not so bad do seem to have this sense that really the tenant really needs to prove that this landlord is not going to do this, because I'm inclined to think that, you know, they have the right to move in and they probably will. It's a little off track, but again, the benefit is it may provide an evidentiary base for your 12-month claim. Are there any questions? Somebody's keeping track of the
No.
Zoom attendees? There's
Yeah,
no
nothing in the
questions?
chat.
Okay.
Thank you.
Well, I mean, it's 9:45. If there, Emma? Okay.
So that I can. Thank you. It's just like a summary. So then, my colleague and I were discussing about the vacate clauses, and I was explaining that you just said that this is something new from this year. So this should be in the contract where Section E is checked off, vacate clause is filled out under Section 13.1. Then the tenant moves out, the landlord doesn't comply with the vacate clause. So now the tenant can bring forth the 12-month.
Yes.
Correct?
Yes.
And then for the 2-month notice for landlord's use of property, there is the sale done by the landlord. And then the purchaser says, I want you to evict the tenant. Then the seller moves in, or the seller pretends or intends in good faith to move in, but they don't. That's also when you can bring a claim forth for 12 months.
Yeah. And we would advise against both the seller and the purchaser, because you may not know the details of their interactions.
Okay. And so then that's what we were discussing here with my colleague, that there might be a different level of claim, in the sense that it may not be the best case scenario to go and dispute that.
Yeah. I mean, sometimes, I heard one advocate saying that they sometimes just advise people, you know, if they're in a position where they can move under a 2-month notice, and if they think they'll be able to keep an eye on the property, to just move under the notice, get their 1 month compensation, and then try to put together the evidence they have that the landlord's not doing what they're saying, and make a 12-month claim.
And that is for the 2-month notice. Then we have the 4-month notice for renos and repairs, and the demos and the conversion, right?
Yeah.
And then you can bring forth a claim of 12 months of payment of rent if the landlord did not comply by giving you the 45-day notice, but the tenant needs to have submitted the right of first refusal, right? If the tenant did not put it in, they have no case. And the landlord, if the landlord forgets, which is very likely, we have seen some cases, then the tenant can apply for the 12-month comp.
Yeah.
Okay. Yeah. Just summarizing it so that we have been discussing.
Those are sort of the 3 avenues: the landlord use, where they don't fulfill the intention, the vacate clause where they don't move in, and finally the right of first refusal. That's not, those are your three kind of entryways to the 12-month claim.
Thank you.
And these policy guides that I linked to, and the PowerPoint is up, so you can download it if you want to look at it. But the policy guidelines have been updated, section 30 and section 50, explaining the basis of these claims and explaining the onus and burden of proof. So that's usually my first step. Like I do a lot of sort of summary advice on 12-month claims for people. We don't really handle many of them at class because they are compensation claims, and often tenants are in a position where they can handle making the claims themselves. And just because they're not urgent eviction or urgent repair issues, we just don't have capacity to deal with them that often. But we get people calling or asking about them quite a bit. And I always just go back to these policy guidelines. Like there's some details in 2A and 2B, which are about the good faith basis, and they explain some of the language. And then policy guideline 50, that's specifically about that 12-month compensation, has some additional detail and definitions or expansions of the meanings of those words. So those are kind of the big go-tos for preparing to advise someone on one of these claims. Yeah, guideline 30 on fixed terms has just been updated to explain the 12-month compensation if the landlord doesn't live there for 6 months. Yeah, so unless there's any other questions, I think we're done early. And we're always happy to take calls or emails from advocates or tenants who need information or advice on proceeding with these claims. The fact of the shift of the burden of proof is really it's a big difference. It actually means that, you know, tenants are that much more likely to really be successful in these claims. The difficulty is in the extenuating circumstances. And we didn't really talk about that because there's not much you can do about that. Like if the landlord is saying, well, yes, I didn't move in, but there were extenuating circumstances and these are what they are. Really, all you can do is look at the policy guideline and refer to the examples that they give. But like we had a case where the landlord said, well, my daughter was going to move in, but then we became estranged. And so she didn't move in. And we were like, is that really, that doesn't feel like an extenuating circumstance the way, you know, my elderly parent died or had to move into a care facility, but it was upheld. So there's a question there.
I had an interesting one recently where the landlord said there was extenuating circumstances. They had bought the house that my tenant lived in, gave her a 2-month notice. She moved out. They did request that she move out, and we had all the documents about that. Also, the owner said his daughter was going to be moving in. He bought the house. He did tour the house, but he didn't get an inspection done of the house. And so when the tenant moved out and they went to move his daughter in, she said she didn't want to move in because it wasn't in good enough condition. So they started doing renovations and decided that it was too extensive. And so they immediately, like within a couple months, put the house up for sale and it sold. So our argument was that it's not extenuating circumstances that you didn't get a inspection of the home. You should have known what kind of condition it was in. And the arbitrator agreed, and the tenant did get the 12-month compensation.
That's good. Yeah. Yeah, it's helpful to have those kinds of cases on the record. keep thinking about trying to set up a database of like useful decisions. We know that those decisions aren't binding on arbitrators, but if you find cases where the law is set out and there are useful facts, then I do always use those cases as, you know, they should be persuasive according to common law. Anything else? Anyone else?
I have a comment from the chat. Sorry, I
Okay.
lost my connection on my computer, so I understand that the policy guideline 30 specifically puts the burden of proof on a tenant in a 12-month rent claim involving a vacate clause. I know it would still be best to proceed based on the assumption that the tenant has to prove their case, but is there a possible case to be made that this policy guideline is an incorrect interpretation of the legislation itself? In other words, does the wording of the legislation justify treating eviction notices and vacate clauses different?
That's a good question. If it was just in policy, you certainly could argue that. I don't know if I included the actual section. Yeah, I mean, that's an argument that you can always make about a policy, that the policy can't supersede the legislation. I doubt that you would be, I doubt that you could be successful in making that argument. I feel like, yeah, sorry, again, I don't have it in front of me. Anyway, I guess the bottom line is if it's set out in regulation or in the legislation, then it's absolutely binding. If it's just that it was established by policy, the burden of proof, then you could argue against it. I just don't think you would be successful because that's an interpretation guidance document that's produced, you know, by an expert tribunal for the purposes of making these decisions. So, but I'll see if I can figure it out and post that answer somewhere.
Thank you. I have another comment from the chat that says, the legislation doesn't really seem to say anything about the burden of proof. In the case of eviction notices, am I right in understanding that the policy guideline was changed following a judicial review?
For the burden of proof for evictions?
Yes.
Possibly. Often the policy guideline will refer to a specific case. I don't recall seeing that for, I don't recall seeing that in the policy guideline. Yeah, I'm afraid I don't know the genesis of that. I mean, it makes sense in the sense that when an applicant, when somebody is advancing a claim, the burden of proof is on them. So in the case of an eviction, it is the landlord who is advancing the claim, even if they're not the one that made the application in the first place. So the really confusing thing about that whole process is that even though it is the landlord's claim and it is the landlord's burden of proof, there's an obligation on the tenant as the applicant for the hearing to serve and submit their evidence ahead of the landlord. And I think that could be resolved by shifting that as well, either by making it so that, like the 4-month notice, a landlord would just have to file in order to effect an eviction, and then they would be the applicant, they would have to file their evidence, and the tenant could be the respondent and respond. That would create less sort of cognitive dissonance when you're trying to sort these things out.
Thank you.
Michelle, when is the best time to start at the 12-month claim? Because the law said that the landlord have to be living there for 6 months. So people often are very confused that they have then to wait these 6 months, and then maybe if they didn't move at all for the 6 month apply.
Yeah, I mean, there's no hard and fast rule.
There
That's
is
what we
no
were saying. You kind of have to try and strategize, because if you file too early, then you're just giving your landlord the opportunity to move in or purport to move in or start making up excuses why they haven't moved in yet. Whereas if you wait at least the 6 months, maybe plus a little bit, you have a much better, I think,
Okay.
opportunity of advancing that claim without giving the landlord any wiggle room to make last minute changes. But there's no
There is no
real answer. I would say don't jump on it in the first few months, because there are also legitimately reasons why a landlord might not be able to move in. You know,
Right
maybe
away,
they
yeah.
did an inspection, but the inspection didn't uncover some, you know, hidden defect. Maybe there's a foundation wall problem, and it is going to take them a couple of months to get enough, you know, for materials and workers or whatever to come in and repair that issue. By 6 months, that possibility is starting to recede into the distance, and it becomes far more likely that they're just not going to do that. Of course, in a case where they've already rented out the place, that's different, right? If you have evidence that the minute you moved out, they did a 4-week reno and put in some granite countertops, and now it's on Craigslist for $5,000 a month, then yes, sure, go ahead and make that claim.
And what about renovation? If the landlord start doing some renovation, can you apply right away, or is better to maybe wait a
Again,
little
it depends.
bit?
Like it may be, and it's set out in the policy guideline, like the landlord may find that they need to replace all
Do
the
some,
carpets and they can't move in until they do that. Well, they might find that, again, there was some issue. They need to do more remedial renovation than they expected. It's going to take 8 weeks instead of 3 weeks or whatever. Having said that, if you go and there's a full-scale renovation project and walls are being knocked down, then
that's
take
maybe
take
so
pictures,
different.
and maybe it makes sense to make that claim sooner.
Okay, thank you.
You're welcome. That's it. I think that's really it. We're going to wrap it up here. Thank you. Thank you for coming, and sorry for the delay at the beginning.